Hello. Are we good? I can't hear anyone.
You're good, Vicki.
Yeah,
Okay.
you should be good to go.
Okay. Welcome and thank you for your attendance. I am Vicki Turner, your 2020 Professional Standards Chair, and it is my pleasure to work with our Vice Chair, Matt Silver. We have an esteemed panel of speakers with Bruce Eit and Matt DePonis, as well as our committee members giving us reports. So again, welcome, and I'd like to call the meeting to order. Since this meeting is a webinar, I will not be asking for a motion to approve the minutes. The minutes are in your handouts, and if you have any changes, please email Becky. You will be able to submit questions through this meeting, and we will answer those questions depending on the time that we have to respond. So first up is Chris Reed with the Ombudsman Program, and she's going to give us an update. Welcome, Chris.
Thank you, Madam Chair. And let me just share my screen if I can. Hold on.
There you go.
Okay. All right. I'd like to, because this is a Zoom and because we're in it, we might have additional members. I'd like to give a little bit in my report, a little bit of a background on the Ombudsman Program. And if for those of you who were on the legal forum earlier today, I want to thank Annalise Firstos, who did a very nice description of how and sometimes on the legal hotline, where she will refer some questions to the Ombudsman Program. Illinois Realtors, this has been a program that was established in 2013. And note that in 2013, it was actually in 2014 that NAR passed a motion to make it mandatory by 2016 for all associations that provide professional standards services to have an ombudsman program or have access to it, which of course Illinois was ahead of the game on that. So what is the purpose? As I said, I wanted to give just a little bit more of a background on this before I give my actual report. This is a dispute resolution service, and it is designed to address anything to do with real estate transactions. It is not just the code of ethics. It's not just questions about procuring cause, but can be questions about contracts. It can be questions about how do I get my earnest money back, all over the board. It is a service that is available to both consumers and to realtors. It is realtors. If there is a concern that is filed against somebody that is not a realtor, then we do not take that as a file. And by the way, since these are not formal complaints, I am very careful when I am talking to parties that I say we're talking about a concern that has been filed, but it's not a formal complaint. So when Illinois started the state program in 2013, their goal was to develop the program, make it available within the state, as well as to make it available to local associations should they want to have their own ombudsman program, which today, both Chicago Association of Realtors and Main Street has their own program. They mirror the state program. They have it set up using the same forms, et cetera, that we do in the state. Other local associations refer to the state. We have 30 ombudsmen that are appointed. And the criteria to become an ombudsman is very extensive. You must have experience at the professional, either in grievance, board of directors, professional standards, and have gone through several hearings or on grievance, several meetings, mediation training, and very extensive knowledge on license law, the act, your MLS rules, contracts, and so forth, because as I said, the issues and the questions are all over the board. So who benefits? Individuals, they might be angry, they might be confused, they might be frustrated, they might have questions. It could be two realtors that are maybe having a dispute with one another. It could be a realtor that is thinking about leaving his office and they want to know what should they do. And so maybe it's a question about their sponsoring broker. And so the ombudsman is a resource that would talk to them about their independent contractors agreement. So what are the exact benefits? All right, so it provides an opportunity for a story to be heard. Sometimes people are just, they're frustrated, they want to hear, they want somebody to listen to them, to vent. Sometimes we do need to have them to vent and allow them to get it off their chest. What it does for consumers, it definitely provides an avenue for them to say, hey, you're the Realtor Association cares about the service that you are getting, that are being provided to you. And so it is an avenue for consumers to be able to ask questions, to get guidance. So we field complaints, field questions, we provide education. And if there is a concern, and many times there is a mediated solution, and that will, if it's a dispute resolution service that can come to a happy meeting of the minds, then it avoids hearings, it avoids for extended time on not only the part of the parties, but also on part of the staff and other realtors that have to do the hearings. And the last bullet on there, I think, is an important one too, where we all know that there are things that happen in the marketplace, in the industry, that they don't always get reported as violations. They don't want to go through that process, but it's easier for them to go through this program, and so that they feel confident that the issue is addressed. They just want to change behavior. So that in itself has resolved many different issues in the past. What an ombudsman is not, we are not the judge and jury. There's a big, long script that we share when we start to talk with either the consumer or the realtor. We call it a complainant, but they're not, again, it's not a formal complaint, but the person who has filed the concern. We're not the judge and jury. We just want to hear what it is that they're concerned about and what is it they're hoping to accomplish. The ombudsman does not determine whether there's an ethics violation. We do not give legal advice. We do not refer concerns to the grievance committee or regulatory body unless there's a public trust that is violated. We don't put anything in writing. We don't review anything in writing. A lot of times they want to send things to us. No, that's not my job. My job is just to listen. And we do not act as an advocate for either party. It is a very confidential process. We call the other party only when there is permission granted. And we ask them, is there anything that you do not want us to share going to the other side? And the last on this is, if this does become a formal complaint, the ombudsman cannot be called in as a witness, and all notes that we make as we're going through are destroyed. The committee members have the file, the report to you that Becky Caraher keeps track of on a regular basis. She's been doing this since the beginning. What's on your screen right now is just a summary of the 2020 files. And I did this first because I want you to see the kind of topics that are talked about. And because the committee has, you can see it from year to year, and sometimes there's changes, but your biggest ones on the top: business ethics code, contracts, contract presentations. Those are on a recurring theme, your biggest topics, biggest questions and concerns that people have. Earnest money, how do I get my earnest money back? By the way, contracts and contract presentations, so many times that a consumer says, oh my gosh, I lost, they didn't even tell me I was in multiple offer. Why didn't they give me that opportunity? By the way, interesting that like in this is 2020, 177 files. And each year it's interesting that At the state level, it's about 80% of the files that are opened are coming from the consumers. When Chicago Association and when Main Street gives their reports, about 80% of their ombudsman files are coming from realtors. Kind of makes sense. The realtors go to their local association. The consumers find their way to the state. So a lot of these are coming from the consumers. Repairs, disclosures, leasing, property management, commission disputes, advertising, discrimination, public trust. These are all some of the topics that we've seen in 2020 so far. And just as you can see at the top, so far to date to the end of August, there's been 177 files. In 2019, there was a total of 2005. And I think the highest year that we did was in 2017, there were 292 files that were opened. When a file is complete, the ombudsman sends in a summary log that says close out the file. And by the way, sometimes these calls can be the file, should I say, the case or the assignment, whatever you want to call it. It might be one call. If they don't give you permission to call the other party, they just wanted education, then that file is complete. Sometimes it's 2 calls, sometimes it's 5 calls, sometimes it's 20 calls. Sometimes you're done in 1 day. And I've had some that have gone on as long as a month and a half or 2 months. So it just depends on what the situation is. But when we're done, we report back. And these are some of, as far as those 177. Now don't add up because there are still some that are pending. So these numbers do not add up to the 177, but you can see that you look at the top 2, resolved to the complainant's satisfaction, education provided, 50 plus 42, that's 92. That's a good percentage. That is a service that has been provided. Complaint withdrawn. There were 26 that are intending to either file for an ethics complaint or they're going to the regulatory body of IDFPR to file there. And as sometimes it should be filed, that they don't want to mediate an ethics, they want direction, and that's what the ombudsman would be providing then, is their options of what direction that they can take should they want to file a complaint against a formal complaint. Directed to seek legal service, 20 cases. I've had several this year that there's definitely been mistrust done and that they should be seeking the legal service. No resolution, 18. I think there were 2 cases that were turned away because they were not realtors. And like I said, there are still some that are pending. I want to thank, as part of my report, I want to say thank you to the 30 volunteers that for the Illinois Realtors. When they are appointed, they have a 3-year term. They, like I said, sometimes it's 1 call. And by the way, when they get an email, the object is for them to talk with that person within 4 hours. That's one of the successes that we have had with the program, is that, especially with the consumer, that if they can get someone on the end of the line that is going to listen to them within a 4-hour period, that in itself is a huge win and makes them feel comfortable and feels that somebody is listening. So I want to thank the volunteers for their time. I want to thank the local associations that support, that send, that refer to the state association, and obviously the Illinois Realtors staff. As I said, Annalise Verstos in the legal forum, it was a classic example of how staff supports the program and suggests people to use the program, to direct it to that. And Becky Caraher, who is the best, she lives with her phone. When a concern comes in, she immediately is looking to assign it to someone and to make sure that the system flows through. We've been doing this in 2013. I personally have had a number of ombudsman cases that on my summary long, I said, this is a classic case of a service that has been performed. A consumer or a realtor has received the education that they needed, and it's been a great program. To the ombudsman who might be in the audience right now, we have a meeting coming up on October 21st. Every year since we have been in, since 2013, one of the other goals that we had when we set this up was to make it a living document. And so every year, typically it was in June. This year, because of pandemic, it's been put off, but on October 21st, we will be having a Zoom meeting to get together with the ombudsman to share concerns, to share ideas. Are there new resources that are needed? We have developed a number of scripts over the years to make sure that our service is and our message is being delivered in a consistent manner. And so the members will be meeting via Zoom on October 21st. And Madam Chair, that concludes my report. Thank you very much.
Thank you so much, Chris. It's really a great program. And once again, Illinois really took a leadership role in getting that program started. So thank you, Chris, and thank you for all that serve on that committee. So today, Bruce Eit will be talking to us about Article 10 of the Code of Ethics. Bruce is a realtor, attorney, and educator from St. Louis, Missouri. Bruce has been involved in the Realtor Association work throughout his career. He has served in leadership roles as president of both the Missouri Association of Realtors and the St. Louis Association of Realtors. Bruce has been part of the National Association's enlarged leadership team 3 times, and he has chaired the NAR Professional Standards Committee, Legal Action Committee, and the State Leadership Forum, and received the National Association's Distinguished Service Award. He is one of 3 trainers for the NAR Mediation Training Seminar and a regular columnist on ethic issues for Realtor Magazine. And if that wasn't enough, he has been known to tell a good joke or two. So please welcome a true Illinois realtor friend, Bruce Eit. Welcome, Bruce.
Thank you, Vicki. Appreciate it very much. And actually, my roots are in Southern Illinois. I have a lot of family over in the Belleville area and Southern Illinois area. So yeah, I sort of regard myself as an Illinois, maybe adoptee, we'll say. So
wonderful. We'll take you.
Yeah, thank you very much. Appreciate the opportunity to be here today. And as Vicki mentioned, I'm going to talk a little bit about Article 10. I guess Article 10 is a very topical thing that we might want to talk about now because of the many things that have gone on in our country, across the country, in Illinois, related to race relations and housing issues. Probably, if you are not aware, try to be aware of the very significant article and study that was done on Long Island by Newsday publication, very, very well researched, that unfortunately really revealed a tremendous amount of discrimination, steering, and activities that were not appropriate and not within the spirit of or the letter of either the Code of Ethics or the fair housing laws. So, excuse me just a second. So let's talk a little bit about the basics of Article 10 and then the individual standards of practice under Article 10. And you'll see a little bit of where we are now. And then Matt, I think, is going to give you a little bit of idea of maybe some of the things that we are perhaps considering or talking about. So Article 10, of course, fair housing and equal opportunity. And basically the article itself is premised upon three different things. And this is the actual article. I usually like to give you the actual words, but then let's break it down into the pieces that are there. And really it comes out, in my mind, to three different things. First of all, first concept is we as realtors shall not deny equal professional services to any person on the basis of the protected classes. Secondly, not be parties to any plan or agreement to discriminate on the basis of the protected classes. And then third, in our real estate employment practices, shall not discriminate on the basis of the protected classes. So conceptually, I just want to get out those three concepts to start with. And then I want to go back for just a second and talk about the protected classes in the Code of Ethics versus the federal law versus the what you have in state law. So notice that the code talks about the protected classes as race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. That is two more. Sexual orientation and gender identity are included in the Code of Ethics that are not included in the Federal Fair Housing Act. Now, Illinois has a whole series of additional protected classes, and unfortunately I did not put a slide together on the Illinois protected classes, but there are at least 4 or 5 additional ones. For example, status as a veteran is one of them. And then you get down to the local level as well. And for example, Cook County has its own protected classes as well. So remember that when we talk about the protected classes within the code, there are additional protected classes both statewide and on a local basis as well. So when we talk about protected classes in this context, we're talking about the 9 protected classes in the Code of Ethics itself. So there are several standards of practice that flow directly from those 3 concepts. And in particular, most of them flow from the first 2 concepts. First one is really related to standard of practice 10-1 and 10-2. Both of these are about volunteering demographic information about racial, religious, or ethnic composition. Standard of practice 10-1 is about residential transactions. And in essence, the real quick answer, the quick synopsis is that volunteering demographic information in a residential transaction is not allowed. Now, that's related to volunteering demographic information about racial or ethnic composition, I should say. However, standard of practice 10-2 is about commercial and non-housing transactions. In that case, volunteering demographic information is allowed with certain limitations. And those are the things that we're going to touch on and get into next. So first, let's talk about standard of practice 10-1. Key phrase at the very beginning: when involved in the sale or lease of a residence, realtors shall not volunteer information regarding the racial, religious, or ethnic composition of any neighborhood, nor engage in what's called panic selling, but may, in fact, provide other demographic information. So things like income levels, those would not be a prohibited demographic piece of information that you could distribute. So let's kind of break this down. Number one, in residential transactions. So remember, the Fair Housing Act deals only with housing. Article 10 is modeled after the Fair Housing Act. So here we're talking only about residential transactions. Now that's leasing transactions as well as sale transactions. In residential transactions, then you're not allowed to volunteer information about the racial, religious, or ethnic composition of any neighborhood. You're not allowed to engage in what's called panic selling. Another term for panic selling is blockbusting. I have not seen reported, anyway, I have not seen a reported case of blockbusting in many years, but it is a very overt practice which is also known as panic selling. Essentially, it occurred a lot during the 1960s and early 70s, and it would be when a real estate practitioner would go through a neighborhood and tell parties in a neighborhood, in particular, in this case, blacks are moving into the neighborhood, therefore your property values are going to go down, therefore you better move, and wouldn't you want to list with me? That's known as panic selling or blockbusting. And in the 60s and 70s, it was primarily used with the ethnicity of Black persons, but it's not restricted to that. It could be related to any of the protected classes. Muslims are moving into the neighborhood. Jewish people are moving into the neighborhood. Gee whiz, this place is getting overrun. There's all these kids in the neighborhood. Don't you want to move since you're out, since you don't have kids anymore, you're empty nesters. Any of those things would be potentially in this vein of blockbusting if you had never actually heard of that. You may again provide other demographic information, which, as I said, for example, income size, income amounts, education levels of the neighborhood, anything that, statistically you might be able to see on, for example, the Census Department, you may provide that other demographic information. Standard of Practice 10-2, this is the complete standard of practice. And again, we said when not involved in the sale of a lease or residence, that's a commercial or non-residential transaction. You can provide demographic information under certain conditions. So in a non-residential transaction, you can provide demographic information, including racial, religious, or ethnic composition of the area. If you do that, the information has to be deemed to be needed by the realtor to assist with the transaction or complete the assignment. The information has to be obtained from a recognized, reasonable, independent, reliable source, and the source of the information and any changes to the information have to be disclosed. My example of this is basically considering and thinking about any kind of retail operation, say a chain operation. I can assure you that Walmart, Target, Walgreens, any type of a large chain store operation will know the demographic information of the area that they serve so that they can have, for example, appropriate product mixes, appropriate locations where they want to locate their stores, and other information needed to run the operation. The other example I use is that if I'm going to open an ethnic grocery store, I'm probably going to want to know where my clientele may be the most concentrated in terms of residing, especially if I want to be close to my clientele, which likely if I'm running an ethnic grocery store, I may want to be. We have, for example, in the St. Louis area, we had a large immigration of Bosnian population in the 1990s. And then there were retail operations which were specifically directed to and carrying Bosnian products for a long time, located in areas where Bosnians had immigrated into our area. Now, there's a much broader spread at this time in our area of where people of Bosnian heritage live. And so maybe it's not as important today to know, oh, well, gee, is there a concentration of this group or that group so I can locate my ethnic store in that area. But that's an example of where it's perfectly okay. It's a commercial operation. It's a non-residential transaction. It's not about the Fair Housing Act. And it's in a situation where a commercial operation to do business is going to want to be in the areas that fit with either its product line or you know, in the situation of like Walgreens, they don't want to be too close to another Walgreens or too far away from another Walgreens. They want to have the right population numbers. And so that's why this standard of practice addresses those commercial types of transactions. Standard of practice 10-3 talks about advertising. And this is very closely connected to the advertising prohibitions in the Fair Housing Act. Talks about not displaying, printing, or circulating advertising that expresses a preference, limitation, or discrimination based upon the protected classes. So let's try to kind of break that down again, break that down a little bit. So print, display, or circulate. The Fair Housing Act talks about publish advertising or making advertising. In a lot of ways, those are almost the same types of words. Clearly covers any kind of digital operation as well as print operation. So any statement or advertisement with respect to selling or renting property that indicates a preference, limitation, or discrimination based on the protected classes. Preferences are sometimes very hard to understand about why that's a problem when you might indicate a preference for a particular group. And essentially what HUD says, and the Code of Ethics follows this concept, is that when you're expressing a preference for a particular group, you're kind of automatically expressing a discrimination against any other group. So whether you say, oh, gee whiz, close to St. Mark's Catholic Parish, that's a preference stated for Catholics. Well, you might say to yourself, well, I don't intend it that way. And the important part to remember about any of these fair housing advertising issues is that it has nothing to do with what you intend. It's how the ad is perceived by the public. So a statement of preference about religion, about ethnicity, or anything of that nature is definitely to be avoided under both the Fair Housing Act as well as under the Code of Ethics. Standard of Practice 10-4 connects directly to the last paragraph of Article 10, and that's related to equal treatment in our employment practices. And what this standard of practice does is to clarify that real estate employment practices includes not just employees, but also independent contractors and any administrative or clerical staff directly supporting those individuals. So it's anybody who works for the brokerage. Don't get too tied into that idea of employment practices applying only to employees. So that's kind of a quick overview of the various pieces of Article 10 and the standards of practice. Vicki, I'll turn it back to you.
Okay, thank you, Bruce. And Becky, do we want to take some questions or wait till the end?
I don't believe any questions. I don't believe any questions were submitted.
Okay, thank you so much. Thank you, Bruce. Next up is Matt DeFanis. He is one of our very own, an Illinois realtor from Champaign, and is the current chair of NAR's Professional Standards Committee. Matt will address us on NAR's Professional Standards Interpretations and Procedures. Welcome, Matt.
Hey, Madam Chair. Thanks so much for having me. And I get to give you the mother of all teasers. Bruce and I get to serve together on the Professional Standards, Procedures, and Interpretations Advisory Board, which is a smaller, more specialized group that tends to dive deeper into the professional standards weeds. INTERPS, as it is colloquially referred to, often gets recommendations sent over from the full committee, which is over 100 people, if there's something that needs a deeper dive, recommendations polished up. We are in the final stages of getting a package of recommendations that will be released for consideration by the full committee. We are not quite there yet, which leaves me to give you the mother of all teasers and to at least tell you, give you an overview of the landscape that has led to a flurry, really an unprecedented flurry of meetings that have spanned the last 2 months. And we've had, I think, 5 or 6 off-cycle interpretations, interps meetings. So going back to what Bruce referenced about the timely nature of Article 10, which is always relevant, but has become really vividly so against the backdrop of the Newsday expose from late last year. And then you insert the current racially and politically charged environment that we have been in particular, starting with the immediate aftermath of the George Floyd killing. And the full Professional Standards Committee, so what I'm about to tell you is not confidential because it's already been on a published agenda. The full Professional Standards Committee was assembled for a special meeting off cycle, not in legislative, not in November, in early June, I guess. Does that sound right, Bruce? Late June, early July. And we did two things. As the chair of that committee, I convened a panel of Black realtors, and intentionally Black only, because at this point, really the real touchstone has been the Black Lives Matter movement and issues most specifically relating to Black Americans, not to exclude similar issues that pertain to other groups, other people of color. But what has been happening is this unprecedented tsunami of realtors behaving badly. And by behaving badly, what I mean is the most typical pattern is somebody who is readily identifiable as a realtor because they've got realtor branding or they've got real estate industry branding. So it's clear that they're a real estate broker and they happen to be a realtor member, posting crazy, racist, bigoted stuff on social media. And so what was happening is the NAR Professional Standards Committee staff liaison received, and these were all published as several examples were published as part of our agenda appendices for our special meeting, just appalling instances of bigotry and racism. And most of the examples were racially insensitive or racist against Black Americans, but there have been some pretty egregious examples very recently that were anti-LGBTQ, very anti-LGBTQ. And so this issue is we are having this crisis where local associations and state associations both were sending in letters, you, NAR, have to help us because this is escalating out of control. And we need something to be able to do because right now, short of it being an imminent threat to public health and safety, and I'll give you one of those examples in a moment, where membership can be, you can kind of skip most of the due process and just terminate membership. Short of that exceptionally high standard, realtors behaving badly on social media, realtors being bigots on social media outside the confines of a real estate transaction or real estate activities is certainly within the spirit of the Code of Ethics, and it's within the scope of the preamble of the Code of Ethics, but it currently sits technically outside the reach of the Code of Ethics and its sanctioning abilities. Because in the Code of Ethics and Arbitration Manual, while the preamble makes clear that this is all aspirational and we as realtors pledge to live by the code, you can't be sanctioned except for violations that occur within the confines of a real estate transaction or real estate related activities. And that limitation is in policy statement number 29 in the Code of Ethics and Arbitration Manual. Any of you who suffer from insomnia might want to try this as a non-pharmaceutical remedy, reading through that at some point. So that's the issue that was laid before our committee. Our special meeting of this Professional Standards Committee was to look at what the Professional Standards Committee might recommend in the way of changes and or expansion of the reach of the code. We also had a special panel that I alluded to earlier, which was a panel of 5 Black realtors who did about an hour and 15-minute no holds barred discussion on race. Because I'll tell you, as a white guy from central Illinois, from the cornfields, so I'm not from a big urban center, and I'm also from what I would like to think of as a very progressive small metro area because I got this Big Ten research university in my backyard. People that look like me, it's very easy to think the stuff that Bruce talked about has its origins now 52 years ago in the Fair Housing Act. NAR a few years later followed suit, mirroring the Fair Housing Act when it reorganized the code and did Article 10. And so many of us, myself included, have literally never seen a fair housing violation with our own eyes. And it becomes really seductively easy to believe that that means that they don't happen. It's a history lesson. fair housing vocabulary is hammered into us. It's a must cover topic in core continuing education, without realizing that it is still not just relevant, but pervasive today. So our panel did exactly that. And those panelists included several all-stars from Illinois. It included Zeke, it included Sarah Ware, and it included Courtney Jones, who's the president of the Dearborn Realtist Board, as well as Joanne Poole from Maryland, from Metro Baltimore, and Bikel Fresnel, who's a good friend from Georgia. But the end result of that committee is, I'm hosting a committee meeting with over 100 people, and we're hearing these firsthand, recent and current stories from these Black realtor leaders. And I'm watching my gallery view on my screen of dozens of professional standards committee members physically recoil in shock and horror and repulsion at what they were hearing. So I am here to tell you that, as somebody who has not seen a fair housing violation happen with his own eyes, we have overwhelming evidence, just overwhelming, devastating, damning evidence that isn't because it's not still epidemic in our industry. And so the mother of all teasers is, that's the issue that was served up to the full committee. The full committee referred it over to the Interps group to meet on it, discuss it, chew over it in more detail, and come up with a proposed package for the full committee to consider. That's all going to be happening within the next few weeks. At the latest, it would happen at the November meetings, but I expect it's all going to go through the committee meetings sooner than that. And those will be released. But as we see those proposals that I know will make news within the industry, I would just ask that, with that bit of background in the back of your mind, ask yourself some questions. I think NAR's That's Who We Are public awareness campaign is the cleverest public awareness campaign ever. It's one that really does highlight so many things outside of real estate that realtors do, that in essence means that realtors are interwoven into the fabric of society. We're really integral in all of that. And yet every time we allow a realtor to be a bigot on social media by night, while claiming that they are committed to living by the letter and the spirit of Article 10 that Bruce just gave us the deep dive into by day in the course of their day job, does that really sound credible and convincing? And if you were a consumer of color and you are seeing that kind of vitriol and hate speech bubbling over from that individual's social media channels, are you, as a consumer who's in one of those protected classes, really going to think, I can count on that person who does that to give me equal treatment under Article 10? So there is your teaser. Please stay tuned. But there's your background, and there's a question for you to ponder.
Okay. And did we get any questions for Matt? I don't see it.
Vicki, can I?
No, I don't believe it.
Yeah, just a comment or two.
Sure, absolutely.
So I guess I really want to follow Matt's comments with, connecting to the preamble to the code. And the preamble to the code specifically talks about things that we have a responsibility as realtors to eliminate practices which might damage the public and bring discredit or dishonor to the real estate profession. And that truly is what we are working towards right now as we look at all of this massive amount of evidence and information that we have received. And quite frankly, I just, while it's every time you hear these things going on, in one respect, I'm a white guy just like Matt, and you kind of go, what? On the other hand, I unfortunately, in listening to our Black professional colleagues, I was shocked, but I was not shocked because of the Newsday study, because of things that I too, with my Black colleagues and realtors that I have known who have in fact been subject to this. It is something that continues to need to be addressed, and we need to follow the code and really dig into the preamble to the code. So thank you for that opportunity to make those few additional comments.
And I guess I would just say, if with that's who we are campaign, if we allow what's been happening to continue to happen, like it or not, the most offensive, inappropriate, bigoted hate speech out there, that will become who we are as far as consumers are concerned. And I would just implore all of you to make sure when you're asking yourself that question that you realize I'm not willing to let that be who we are. I'm not willing to let that be who I am as a person. And I'm not willing to let that be any sort of a representation of our brand. In other words, if there is an opportunity to do so, I want there to be teeth in the ability to enforce sanctions against people that do things like that while cloaked in the realtor brand.
Absolutely. Well, thank you, Matt and Bruce. Very timely and sadly very needed. My personal mission right now is I'm living by the motto that it's not enough to be who I am. I have to work to make a difference. So thank you for that great information. We'll look forward to hearing more on what you guys are working on. So next up is Cheryl Greider Whitehurst, who is the current chair of the Ethics Citation Panel, and she will share a report on that program. Welcome, Cheryl.
Thank you. See if I can get my screen share going. 1 second. The thing is hiding my, there we go. Couldn't find my controls to start my slideshow. So just again, a brief overview about the Ethics Citation Program. It was started and our first ones were filed in 2015. And it was designed as a program to speed up potential code violations on certain codes and standard of practice. And the information can be found on the Illinois Realtors website if you want to learn more about the program and where you can file. So a summary of the complaints filed, as you can see, the different years. Sometimes what we review is sent to the grievance committee because we feel like more needs to be resolved. Maybe it needs to go to a hearing. Then you can see out of those how many citations were issued, and sometimes those parties request a hearing. They dispute maybe what our decision was, and sometimes based on the facts that they submit, we might reconsider. So for this year, you can see we've had 172 so far through August, which we're averaging about 21 and a half per month that our committee reviews. We meet monthly we try to keep it in an hour. So based on those stats, we'd be about a 258 by year end. So hopefully not. Again, out of those, we only issued 63 citations. So we don't issue a citation for everything. There's sometimes evidence that isn't enough, or we believe the person submitting the information is wrong. So for 2020, just a breakdown of those citations that were issued. The first one is under Article 1 and Article 3 for unauthorized access. So we issued 17 citations so far this year for unauthorized access. To me, that's just totally unacceptable of us entering property without authorization. So hopefully we can do better next year. The next category is failure to disclose existence of accepted offers. We had 1 citation issued for that. 4 citations were issued because the realtor didn't disclose their interest in the property. We have had for advertising under just the general Article 12, 17 citations issued. As you will be able to see, Article 12 is our biggest area with advertising. 20 of them failure to disclose their firm name in their advertising, and 1 citation for falsely claiming to have sold a property when they did not. And that is the end of I'll stop my screen share and see if we have any questions.
Any questions for Cheryl?
Not at this time, no.
Okay, thank you, Cheryl.
You're welcome.
Well, obviously, we've learned we have much work to do, and I know many of you on this call today will be part of doing that work and making a difference. And I applaud the systems and items that we already have in place to make all of us better. So thank you for volunteering your time, knowledge, and expertise. So regarding the 2020 Pro Standards workshops, at this time, a decision has not been made as to what will happen with the January workshops. Leadership and staff are still considering different options, so stay tuned. And finally, under new business, one thing that I'd like to just mention to our committee, just a gentle reminder that when you're serving on an online hearing, the same rules apply with your body language and your facial expressions. They're just as important as at a live hearing. So please bring your poker face and be very aware of what's going on and around you in your virtual space. So just a little reminder there. Does anyone else have anything they'd like to share under new business? Okay, Becky, anything that came in, any staff that we should talk about?
Let me check with Mindy real quick, but I will say since the pandemic has hit, which was in March, we have had 24 hearings via Zoom. And I must say that they're going fine. They seem to be working out well. And I do want to emphasize, if you're going to serve on a hearing panel, make sure you log on early. I always recommend at least 10 minutes. So if we are having any sort of technical issues, we can deal with those before, the rest of the parties enter the hearing. And like you said, always be well aware of your facial expressions because you're on video and your face is out there and everyone can see it. So.
Yeah, and just in conversations that I've had with Becky too, we've kind of been monitoring feedback from the parties involved, and we don't feel like they're feeling like anything is being shortened in any way in the process by doing it virtually. So it's been quite successful.
Yes, I think it's gone very well.
Yeah, okay. So thank you again. It has been my honor to serve. I appreciate each and every one of you for making a difference. A special thank you to our speakers today, our committee members, and all of you out there in live stream TV land. And a special thank you to Becky for all you do. You are recognized not only at the state level as one of the top experts, but also on the national level. And if I can put in a plug for REEF, our 50/50 is at 3,700. So please take a minute and consider buying a 50/50 ticket or bidding on our silent auction. And if no one else has any other new business, we are adjourned. Thank you.
Thank you.
Thank you.
Thanks, everyone.
Awesome, Matt. That is awesome.
Yeah, it is shocking, but oh boy, a lot of work it sounds like needs to be done, sadly.
While Bruce and Matt are still on the thing, can I ask a question? NAR with their new act, accountability, culture, and training.
Mm-hmm.
How can we get Illinois? They have mandatory sexual harassment prevention training 1 hour a year. They put in X amount of minutes within the core, within the 12-hour. I don't think it's meeting what we need. And with these changes coming about in the code, I think, I don't know, we need to beef up as far as mandatory. That's the only way we're going to get people to get into the class to learn about it, but more mandatory fair housing training. Bruce, you got to unmute.
Yeah, my comment would be, because I don't think Matt's still on, Matt Devanis, not Matt Silver. We did discuss some of that in the current processes. And I would say it's still an open question about how that fits in and what we do in terms of mandatory ethics training, how we fit Article 12 into it. It's already available to be put into there, but the mandatory part is the part that's still being discussed. So you may not see anything about that right now, but it's not a closed subject.
And I'm not so sure it has to go through the code. I'm thinking it should go to IDFPR and make it a mandatory for renewal. I mean, I remember it was, and that came out of housing opportunities. This was back, I'm going to say, I remember Dale Taylor standing up and telling a story about he was not allowed to show a home, and everybody was like a gasp. And the Illinois wrote a letter to IDFPR because it was apparent, you know, fair housing used to be our core B course. It used to be antitrust and fair housing was core B. Well, then somewhere along the line, they started approving anything that was legal was core B. So nobody was taking any fair housing. So that's when they moved the fair housing into core A, and with mandatory minutes. All right, well, now you got one core course and it's supposed to be 45 minutes, but you know, it's not enough. It's not enough. I don't know, I don't know what area of Illinois realtors should maybe write a letter to IDFPR to say, hey, we need to take another look at that as far as mandatory training within our hours, our mandatory hours on fair housing.
One of the conversations I wanted to have with Becky in 3 days, I guess, is it possible to say, like, how do we mandate that in the state of Illinois? How do we make it so that this becomes, you know, you want to be a member of the Illinois Realtors, you have to take this class, whether it's an hour, 2 hours, you know, whatever it is, because it's
no, IDFPR is not going to care about Illinois Realtors, Matt. IDFPR is going to regulate over licensees, and that's what I'm talking about. I think the code, I think what you know, the Professional Standards Committee is going to go and direct that as far as the code, what Bruce does and so forth. You know, you can change what that mandatory thing from the code. What I'm talking about is your license renewal, the 12 hours for brokers. You know,
no, I understand
we got to do 1 hour on sexual harassment prevention training. We should have, you know, a minimum of a whole hour, 2 hours on fair housing.
And I agree with Chris. I think it would be.
Poor Becky doesn't want to see that list, but that's my list for her and I. And that's number one on my list, so.
I'm retiring tomorrow, Matt, so.
No!
I agree with Chris. I think addressing that through IDFPR is better. Plus you get those small licensees in those small towns that aren't realtors.
Right.
Yeah, because there is some of that.
But do we care about those people? I'm totally kidding, by the way.
Careful, Matt.
I know.
Yeah, I think putting something in the license education would be the way to go on that.
I sat on that, you know, education sub panel when we were sort of redoing the CE and how to go about a lot of it. Chris, you remember, and there were a lot of comments at the time, as I recall, about everybody understood fair housing. We weren't really having an issue with it. And why are we making such a big deal out of it? There's many other topics that we should be dealing with. And I know you and I were like, whoa, 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 whoa. Chicago has a huge issue with it, not, you know, to the extent of Long Island, thank God. But I mean, you know, Chicago in and of itself is just such a segregated city that you can't help but wonder how much of that is going on. And so again, if it's starting up here, I'm sure it's trickling down throughout the state. And if it's in the, you know, if it's in the base of the state, it's definitely trickling its way back up. It's a problem all the way around.
Well, I think that's one of the initiatives that NAR is doing, that ACT, accountability, culture, and training. And one of the things that they're looking at throughout on all the 50 states is what kind of mandatory training do they have on fair housing? And I'm
You should
not,
be the leader without question, without question.
so whether it's coming from this committee or another committee or whatever, I think it would be, I think leadership, Illinois Realtor leadership should design a letter to go to IDFPR, encouraging them to look at the whole issue as far as adopting, or maybe we go to Illinois Human Rights. I mean, Illinois Human Rights Act is what mandated the 1 hour of sexual harassment prevention training
True.
that now has to be incorporated into the mandatory brokerage.
It needs to be mandatory on some level, and we just have to figure out with the guidance of the two people in my corners, how we best go about that and make it really happen.
I want to just verify with Lindy, we're not live streaming this, correct?
I think actually we are.
That's correct. Nope,
Okay.
nope.
There's a
It
number
says
of
live
questions.
on YouTube but we took it down from our website, which is where it was streaming. So
But we still have 38 participants online,
you have 31 committee members that are
committee
still.
members. Okay.
Yep.
All right.
Okay, I just want you guys to be aware that other people are listening to this conversation.
Great. Hopefully they all agree.
Well, I just want to give you a heads up, so.
Okay. All right. Well, thank you,
Okay.
Vicki.
Thank you, guys.
You know, the saddest thing about these meetings is we can't say, give you that standing ovation at the end of your, of your term or whatever. But thank you for your service this year as the chair.
Well, thank you. It's been my pleasure, and we had some hurdles to work through, but I think we've done it. So thanks,
Yeah.
Chris.
Okay, thank you all. See you later.
Thank you,
Thanks
Bruce.
for
everybody.
joining
Bye,
us,
guys.
Bruce. All right. Bye-bye. Matt, you and I will take this up again later.
I can't wait. Sounds awesome.
Okay.
Good
All
job
right.
being in lockstep with you, Chris, believe me.
Bye,
All right,
guys.
everybody.
Have a good
nice
night.
Good
Bye.
night.